One of the biggest misconceptions is that being an heir automatically gives you the right to live in the house after a loved one passes. That's not true. I hear this from families all the time. Someone assumes they can just move in or stay there without a second thought, and it leads to conflict and delay. I'm Shanti Sorjono. I specialize in probate and trust real estate here in California, and I help families navigate exactly this every single week. So let's talk about who actually controls the house during probate. Once the court appoints a personal representative, that's the executor or administrator, that person has the legal authority and the responsibility to manage the property for the benefit of all heirs and beneficiaries. They have what's called a fiduciary duty. That means securing the property, maintaining insurance, paying necessary expenses, preserving the home's value, and acting in the best interests of the estate. Now, what if a family member was already living in the home when the owner died? Can they stay? Sometimes. The personal representative may allow them to remain temporarily, but they have to weigh a few things. Does the occupancy benefit or harm the estate? Do all the heirs agree? Is the person paying rent or contributing to expenses? Will living there delay the sale or the administration? The key is that the personal representative has to treat every beneficiary fairly and avoid giving one heir an unfair advantage. But what if someone wants to move in after the owner dies? Generally, that's a no. A family member or beneficiary should not move into the home without the approval of the personal representative. Doing it anyway can create disputes among heirs, delay probate, increase estate expenses, and in some cases, lead to legal action. Let's talk about who pays the bills while someone is living there. Even with someone in the house, the estate remains responsible for protecting the property. That means the mortgage, property taxes, homeowners insurance, HOA dues, necessary utilities, and maintenance and repairs. If a family member is living in the home, the personal representative may ask them to contribute toward utilities and upkeep, or even to pay fair market rent, depending on the circumstances and with advice from the estate's attorney. Can the personal representative live in the house themselves? Yes, but not simply because they're the executor. If they do live there, they still have to act in the best interests of the estate, avoid a conflict of interest, and make sure their occupancy doesn't disadvantage the other heirs or reduce what the estate is worth. They may need to pay rent or get the beneficiary's agreement. What if the house needs to be sold? If the estate plans to sell, the personal representative may need the occupants to move out before listing it. That opens the door to cleaning and repairs, staging, professional photography, and showings, a far smoother sale. Refusing to leave can delay everything and cost the estate money. Can all the heirs simply agree to let someone stay? Yes. If all interested parties agree, the personal representative may allow it, as long as it doesn't harm the estate or interfere with the administration. Put that agreement in writing. Let me give you an example. John dies owning a home worth $900,000. His daughter has been living in that home for several years. The court appoints John's son as the personal representative. The daughter may be able to stay temporarily if the personal representative decides it's in the estate's best interest and it's fair to all the heirs. But if the home needs to be sold, she may eventually have to move so the property can be prepared for sale. Here's what I want you to remember. Someone may live in a house during probate, but occupancy is never automatic. The personal representative controls the property on behalf of the estate, and any occupancy has to protect the estate and stay fair to everyone with an interest in it. If the home is going to be sold, occupants may need to move. And when families disagree, the probate court can step in and decide who has the right to possession. One more time, because it truly matters, this video is general information only. It is not legal, tax, or financial advice, and I am not an attorney. Please speak with licensed professionals about your specific situation. And if you're a surviving spouse, an heir, or an executor here in California, and there's a house involved in the estate, I offer a free, no pressure consultation to help you understand exactly where you stand and what happens next. I'm Shanti Sorjono, and you do not have to figure this out alone.